I'm not seeing Aranet County up, so is that where she?
That was where the last writ was for. Where she is.
Your Honor, if you would allow, so yes, as of in January, our officer prepared a writ. As of, I think, last week, she was still there. I think it was Mr. Trush's understanding she would have been released. If you allow us a few minutes, I can ask someone in my office to, I have asked someone in my office to call that jail to confirm.
And
Thank you.
I would just indicate Ms. Williams is here and ready to go if we wanted to address that while we sort this out.
Okay, Ms. Williams, if you want to come forward. For the record, this is People versus Williams. This is file number 255381. The record should reflect Ms. Williams is present here in the courtroom. Counsel for your appearances.
Yes, Dana Chady on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Williams.
Mr. Trush, can you tell me the status of this file today?
I can, Your Honor. We are in receipt of an offer from the prosecutor that we intend to take advantage of. That would be that if Ms. Williams pled in, and the prosecutor used the district court file numbers, but 251770 FY, that would be the file with a January date of offense.
Okay.
The other file will be dismissed in its entirety, as well as the enhancement on the file she's pleading to. So single count of possession of methamphetamine.
Is that a direct statement of the plea offer?
Yes, and just for record purposes, the file with the issue date of January is 25-5380 FH.
All right, Ms. Williams, if you have a chance to speak to Mr. Trush about this, please.
Yes.
What we had said here on the record today, is that the same agreement that you spoke to him about?
Yes.
Is that how you want to go forward?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Ms. Williams, are you currently on any probation or parole?
No.
You understand that by pleading guilty to possession of methamphetamine, that is a felony that carries with it maximum possible penalty of up to 10 years and or $15,000 fine.
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you. You have the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what you said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information here indicates this happened on January 5th of this year, 2025. Is that correct?
Yes.
On that date, were you present here in Crawford County?
Yes.
While you were here in Crawford County at that time, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Ms. Chady, are the people satisfied with the factual basis?
Yes, Your Honor, thank you.
Mr. Trush?
Yes, I'm satisfied.
Ms. Chady, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush?
I'm aware of none.
Are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
I am satisfied.
Ms. Williams, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. Today you're going to meet Mr. Haven to set up a pre-sentence interview. It's important that you follow through with that and that you stay in touch with Mr. Church prior to the sentencing. Okay.
Okay.
Lodged or is she?
She is not much. I haven't seen her come in yet, but I can go check the lobby.
We're ahead of schedule, so well, let's just take a short break and then come back. Yes.
Sorry, Your Honor, I was just gonna say, Ms. Hilliker was able to contact the Aranac County Jail, and it looked like Ms. Stfan was released on March 12th. So,
Let's go on the record on that one, Mr. Trush. So this is People versus Mallory Stfan, file number 245348. Both counsel are present here today. We've had a discussion about whether Ms. Stfan was still lodged in Aranac County. It appears based on the information people have that she was released on March 12th. Mr. Trush, can you tell me when the last contact you had?
So I actually had a Zoom call with her in the Aranac County Jail on the, that's Ms. Hooper.
Oh, go ahead, sorry.
So I had contact with Ms. Stfan on March 12th in the Aranac County Jail via Zoom. At the time I had contact with her, she had indicated to me that she'd just been sentenced in Aranac to a time served sentence and she expected to be released that day. Candidly, I expected that she would, if released, be transported to our jail since her bond was canceled, but unfortunately, that did not happen.
As far as we know, she's not lodged with us. Okay. All right, Ms. JD, what's the people's position?
Your Honor, this is, I mean, obviously, as we know, I believe it's the final jury status conference prior to a jury trial that's currently set for April 14th. The people are prepared for that trial, and speaking with Mr. Trush, he was also prepared for that trial. I would defer to this court. Your Honor knows that I'm not in here, but I don't know if you would like to give Mr. Trush some time to see if he can call his client, just with those jury trial days set where everyone is prepared. So I would defer to the court what they'd like to do.
Based on your conversations with your client, does she then proceed to trial?
She does. And I would indicate we actually are planning to utilize our second chair program. And we have made arrangements for one of the newer counsel in the area to second chair that trial. My request to the court would be if the court issues a show cause or bench warrant or however the court chooses to proceed, I'd ask the court not to take the trial dates off just yet. I think we have enough time that it's possible we could still find her and proceed.
Okay, I agree. So the court's going to leave the trial date as scheduled. I will set this for a show cause and final status conference at the court's April motion date. And Mr. Trush and Ms. Chady, I'll just ask that both parties continue to work towards being prepared. I don't want the non-appearance today, if she does appear later, to cause a delay in the trial. So I want everybody to go forward as if we're going to proceed on the 14th. If for some reason Ms. Stfan doesn't appear at the April motion date, then we can decide where to go from there. But I anticipate based on your representation to the church that this claim is.
Thank you.
Yes. Thank you.
And are you ready with Ms. Hooper?
I would appreciate if I could have just a minute with her to make sure everything is in order.
Need to go off the record or?
I think we'll be real quick.
Double check. Okay. Hooper, coming forward. We're on the record now in Cole versus Elizabeth Hooper, case number 255374. The record should reflect Ms. Hooper's present in the courtroom.
Dana Chady on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Hooper.
Mr. Trish, can you tell me how we're going to proceed?
Yes, Your Honor, we do have a resolution for the court. Ms. Hooper will be tendering a no contest plea to counts 1, 3, and 5. Count 2 and 4 will be dismissed, as well as the second or subsequent offense, substance abuse or substance enhancement.
Okay. And what is the reason for the no contest plea?
Lack of memory.
Ms. Shady, do the people have any objection to the no contest plea for that reason?
No objection, Your Honor. Thank you.
I do, Your Honor, and I highlighted the summary section for the court, and then I also highlighted on page 9, there's a true narc section that would establish what the substance was.
Talk to Mr. Church about this plea agreement.
Yes, Your Honor.
Discussed here today, is that the same agreement that you discussed with him?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor. I solemnly swear.
Thank you. Lower your hand. Ms. Hooper, are you currently on any kind of probation or parole?
Yes, sir.
Where's your,
Um,
which one?
I'm on probation through this Grayling County here for some stuff that happened in the hospital. I was going and finishing up for a it was like a disorderly conduct because I have some brain problems and memory loss. I was in the hospital. They wanted me to go and I didn't feel competent to leave. So I had ended up getting in a little trouble and I'm doing the probation for that.
Is that what the district court here?
Yes.
Do you know if this plea today is going to be a violation of your probation?
Yes, sir. I think they already, when this stuff first happened, they violated me. And I think actually like next week, I have to come back over here in the district court for that violation.
Oh.
Yes, sir.
So they're aware that you're going to be entering this plea here today?
Yes, sir. And I had gotten a hold of CMH and stuff and tried getting them to help and understand too. I've been straight getting all the help I can for them. I let 2 people come into my home and try to help me, like a care worker.
Well, I don't need to say too much about that stuff yet. There'll be a time to talk about that.
Yes, sir.
So I just want to make sure that I understand exactly what your situation is in terms of court supervision. So you understand that you could face a penalty for violating your district court probation?
Yes, sir.
And that it's separate from this case, you understand?
Yes.
And then in this case, you're pleading no contest to possession of cocaine. That's a felony that carries with it a maximum of up to 4 years and or a $25,000 fine. You understand that?
Yes, sir.
And no contest to 1 count of resisting or obstructing. That's a felony that carries with it a maximum penalty of 2 years and or a $2,000 fine. You understand that?
Yes, sir.
Then the last charge is no contest to tampering with evidence. And that's a felony with a maximum possible penalty of 4 years and or a $5,000 fine. Do you understand that?
Yes, sir.
And then count 5 is also discretionary consecutive. Is that correct?
I believe that's accurate.
If it's part of additional convictions.
1 second.
Yes,
Okay, so that means, Ms. Hooper, is that for that last charge, the tampering with evidence, that the court can but doesn't have to sentence you consecutive. That means back to back as opposed to at the same time. You understand that?
Yes, sir.
With all of those things in mind, what is your plea to each of those 3 charges today?
I plead no contest, sir.
And that's based on the fact that you don't have a good recollection of all of these events. Is that true?
Yes, Your Honor.
I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all of those rights?
Yes, Your Honor.
You understand that by pleading no contest, that you're going to be giving up and waiving all of those rights.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what you said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Ms. Chady, have you reviewed this police report?
Yes, I have,
And
Your
I'm
Honor.
referring to Michigan State Police Report Incident Number 7261-25.
Yes,
After having reviewed that, Ms. Chady, do you agree that it would provide a factual basis for finding of guilt as to counts 1, 3, and 5?
yes, Your Honor.
Mr. True, should be done the same.
yes,
Do you agree with that as well?
yes,
Ms. Chady, are the people aware of any threats, promises, or inducements other than what's been placed on the record here?
No, Your Honor, we are not.
Mr. True.
I'm aware of none.
Ms. Chady, are the people satisfied that the court has complied with statute or rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. True.
I am satisfied.
Ms. Hooper, the court finds that your plea is knowing and voluntary. The court is satisfied, and I'm going to mark and admit that police report that I previously identified as Court Exhibit 1. The court is satisfied based on the information contained within Court Exhibit 1, and in particular the summary on page 9 as identified by Mr. Trush, would provide a factual basis to support a finding that Ms. Hooper is guilty of counts 1, 3, and 5. The court will accept the no contest plea. We'll set this matter for a sentencing hearing. Ms. Hooper, you'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Mr. Haven to set up a pre-sentence interview. It's important that you follow through with that and that you stay in touch with Mr. Trush prior to that sentencing hearing, okay?
Yes, Your Honor.
Ms. Chady, anything further on this file today?
Nothing further. Thank you, Your Honor.
Mr. Trush?
Nothing further.
Thank you, that's all.
Thank you.
Are we ready on Mr. Marvin's case?
The people are ready, Your Honor.
Court calls People versus Michael Marvin, case number 245339. Mr. Marvin is collecting right up to the podium here. Second and counsel, if you're-
Yes, Dana Chady on behalf of the people.
James Sherwood, defendant, Michael Marvin.
Thank you. We're in the record in this file here today, based on a motion on behalf of the people. And it looks to me, after reviewing the motion, is that this looks to me like a paperwork error, where a box that required Mr. Marvin to test for alcohol was not properly checked. Is that correct?
That is correct, Your Honor. So the people are just requesting that the pretrial release order just be amended to include subsection G.
Mr. Sherden, did you have a chance to review that motion?
I did, Your Honor.
Any objection to that change?
Check to the extent that I would amend the order again to prohibit the use of alcohol and other substances, given the amount of time my client has been compliant and, been a participant in the requirements under the order. And given the purpose of the conditions to make sure my client appears as necessary and to ensure that he's not posing a harm to public. I believe both of those policy reasons would be affected if the order was modified, but just to the extent that my client could use an ankle monitoring technology of some sort, because the current PBT testing results are not consistent. There's been multiple alleged violations, and I think that's why people are asking that the current order be amended again so that they can potentially violate my client on later alleged violations of the PBT testing results. But if you look at people's exhibits 3 through 6, I believe you can see the errors that could be attributed to the technology that my client uses to do this screening through PBT. So I just think an ankle monitoring technology may be more efficient to make sure that he shows up and that he's not going to be a threat to the public. And enough to, nearly 6 months has passed since the original order, pre-trial release order. So I think, given his compliance so far, I think it would be unnecessary to continue potentially violating him, revoking his bond while he waits on trial.
Okay, so you don't have a problem adding that as a condition, but you're asking to modify the mode of testing from the current EBT setup to some other type of technology. Did you believe that it's resulting in false positives?
I just believe amending the order again would just give basis to violate my client on conditions, which would be unnecessary given the reason for it just being making sure that he shows up again for his any pre-trial appearances and that he's not going to pose a threat to the public, which I think he's shown over the course of now 6 months.
So I don't understand what is your position on that exactly. They're asking the court to add condition G, I think it is, which requires
Yes.
testing.
So subsection G would be that to not use alcohol, marijuana, or controlled substance. H is the requirement for testing. H is currently checked off. That is what Mr. Marvin is doing with the device and what is included in reports in our attachments. But G, the actual requirement to not use alcohol or marijuana controlled substance, has not been checked off. If you would allow to, the people are a little confused at this time of what the argument that is being made by defense. They did file a reply to our motion on Friday. I don't know if the court was able to review that, but in that response, they were opposing our request for that, but then it does sound like they're requesting an ankle monitor.
So Mr.
So-
Sherman, I'm gonna nail you down then. So that
I can clear it up if you'd like. First, there's a motion to dismiss the people's request to modify the current pre-trial release order, and then a defendant's own request to modify the pre-trial release order to add an ankle monitoring technology requirement rather than imposing a requirement that he not consume alcohol and other substances like marijuana. It could potentially lead to violations of my client's bond, which would be unwarranted, given that those are concerns that he may not show up again, if he may pose a
Okay, so your primary argument is that the court should not add G as a condition, which would prevent him from using alcohol controlled substances. But in the alternative, if the court is going to impose that testing be done differently. Is that what you're saying?
Well, the defendant would request that the court dismiss people's motion to modify the order because they failed to meet their burden under.
So you're saying I should not impose G as a condition of the bond?
Right, I'm just giving you my basis for
I just need to know what you're actually asking for, because you're not following your argument. So you're saying G should not be imposed as a condition to come over there.
Yes.
Okay. And the alternative to that, if the court is going to impose G, then your client's request is that it use a different testing device.
Right.
Okay. All right. I am going to impose G, given the nature of the charges here. Or absolutely orders that people do not use alcohol in particular nature of charges, but any other controlled substances unless they're prescribed by a physician. It's a very standard condition of bond in a case like this with these charges. I think it's absolutely necessary for the protection of public safety that you're not using alcohol and other substances while you're on bond. So I think there is justification at G as a condition, and the court will grant a motion to that extent. In terms of the mode of testing, it's shady to the people making condition on defense's request to switch to the ankle monitor.
Your Honor, this was a request I think was made at the beginning of this case, and there was some, I think, some inconsistencies with the, information or not inconsistencies, but I think there was an issue with being able to properly get that monitor, to be able to measure it. In February, we did stipulate to be using this new system with testing being sent to Miss Koch. At this time, I don't have any more information about that potential ankle monitoring, so would not feel comfortable agreeing to that modification without that further information.
Okay, so Mr. Marvin, what do you believe the issue is with regard to this?
Yes, sir.
CBT testing?
Well, I've been taking it for 5 months with no issues, and then all of a sudden it started popping me. But then within 4 to 10 minutes, it would give me a positive. And it was like he said, it's the same algorithm every time. So I contacted the prosecutor. And this was kind of a big issue. It was kind of a conflict of interest for both me and her. The judge before, not you, but the one prior, before we got bonded over, set her to be in charge of my monitoring system. And when I got a lawyer, she couldn't talk to me. And I was asking her, like, what can I do? What can I do? For the last month. And I've gotten 0 response. And I was told not to contact her. So I felt like I was in an issue that I couldn't solve. So I contacted him and they said, look, she's moved me to 3 times a day now. I'm on 100% disability. I have insomnia. I don't sleep well. It's setting me up to fail. I told him, I said, I have no problem getting ankle monitor that I can test every 15 minutes. I have no problem passing. I have no problem not drinking. But I don't want to be set up to fail. And I feel like if I can go to sleep and the ankle monitor will do its job and I don't have to stress out about 3 random times a day, then I'm fine. I'm not going to have any issues with it at all. But I do believe that I made that very apparent in the beginning that if I did have problems, due to the insomnia and stuff, that I would go on the ankle monitor to prove to the court that I plan to and am sober.
All right, was there something else you wanted to add?
No, Your Honor, I'm just listening as Mr. Marvin is making statements.
All right, to me, Mr. Marvin and Mr. Sherman, it doesn't matter. I don't care what device is being used. What I care about is the monitoring and that there's accurate testing. Because I don't want to set you up for failure either, and I certainly don't want you to have your bond revoked because testing isn't properly or accurate. But if you're tested positive, I want it to be because you're actually using, and in that case, it gives me a reason to revoke your bond, but otherwise I don't want to do that either. So, I'm going to put that back on you and your attorney. If you can get things set up with an ankle monitor where that can be transferred seamlessly and there's no gap in testing, and we have some assurance that this is in place?
I've already contacted them and they just told, the last thing they told me was after they talked to the prosecutor, they were told that they didn't have a court's order and, or that the court denied the order.
Okay.
That's what I was told from the company. I wasn't on the phone call between those two, so, you know,
So,
that's,
Ms. Shady, I'm gonna ask you to, and Mr. Sherman to work together as the attorneys here, or Ms. Pope, whoever's handling it.
Yes.
But for the record, my position is I don't care whether it's this PBT device or an ankle monitor, as long as Mr. Marvin's being tested. Testing's accurate. So, to the extent that there needs to be court approval, you have it. As long as, again, that is set up and put in place so that there's no gap in testing.
yes, Your Honor.
So, and again, I'm gonna put that on the attorneys to figure out how to exactly make that happen from a practical standpoint. And, but to the extent that there's an order necessary for it, you have to sign that.
Yes.
Okay. Otherwise, let's keep doing what we're doing until we can get that in place.
Yes, sir.
Ms. JD, anything further today?
Nothing further. Thank you.
Mr. Sherman?
Nothing further. Thank you.
Just as a housekeeping matter, defense attorney was that he filed a response with the court. I do not have that.
I didn't see it either, so Mr. Sherman, just make sure that when you file things with the clerk's office receives a copy of it in the proper manner under the court rules, and that you send judges copies to my office.
So thank you.
Thank you. That's all.
Um,
Oh, I'm sorry. Go ahead.
I'm sorry, Your Honor. As I'm the only prosecutor today, there is a hearing that's in district court right now that was set for 2. So I was going to suggest if we wait till the scheduled time
Sure.
for Ms. Hansen, I can go there and return. Thank you.
We'll take a short recess. We'll come back on the record at 15 or soon after.
Thank you, Your Honor.
Thank you, Judge.
Good, she's getting all the experience here. Okay, we're on the record in People versus Amy Hansen, two files, file number 245333 and 255370. The record should reflect Ms. Hansen present here in the courtroom. I can have counsel put your appearances on.
Dana Chady on behalf of the people.
Thank you, appearing on behalf of Ms. Hansen. On both files, she's just thanked Lana.
So this is a date and time set for sentencing in both matters. One is a probation violation and the other is the new charge. Yes, if you have a chance to go through these reports with Mr. Germerty.
I did.
Mr. Germerty, as to the violation report, are there any changes that need to be made?
No, sir.
As to the new PSI, any additions, deletions, or corrections?
Just to the new file, no additions, corrections, deletions to the pre-sentence report and none to the SI or either.
Okay, thank you. Ms. Chady, any corrections on behalf of the people?
No corrections, Your Honor. We just have some comments we'd like to state before sentencing. Thank you.
Any challenges to the scoring?
No, Your Honor.
Then anything on behalf of the people for allocation?
Yes, Your Honor. As you stated, we're here for sentencing on a probation violation and a sentencing on a new file. The sentencing guidelines provide a range of 0 to 11 months. Mr. McFalda has recommended 6 months, and the people are asking for 11 months for this sentence for a few different reasons. With the history that's been included in this report, we have a May 20th, 2024. That was a case in Roscommon County involving a dealing and manufacturing of meth. On August 7th, there was an active warrant for this meth-related charge, and the defendant was first arrested for a meth charge here in Crawford County. On October 21st, 2024, this defendant was sentenced on that case. She was sentenced to 90 days jail held in abeyance and probation for 2 years, no additional jail, and a 7411. At that time, this court gave the defendant all of the breaks that the law could give to someone with that type of charge. And on December 21st, 2024, 2 months after that sentence, there was this new charge that we are being sentenced here today. I think in the last few months, the court has given Ms. Hansen all of those opportunities that the law provides. And I think it's clear that she did not consider any of those options the court gave her by 2 months later violating again with more meth. Obviously, we're here. There was a plea done in both of these interactions, but I think her conduct shows just a clear disregard, obviously, for the law, but even the breaks that the court has given her and the opportunities to be successful. We would also be asking that in the underlying file that the 7411 deferral program is revoked. It can be revoked under the subsection upon a violation of a term or condition, and that the court may enter an adjudication of guilt. So that's what we would be asking. Thank you.
Well, a couple of things that I'd like to the last comment matter was the first file that was charged, so shouldn't have any bearing on both the probation violation and the new offense that she picked up. They both, the last comment case precedes both of those. Not to, again, and I say that because I think the Shady had it wrong. The Shady's currently has charges that are pending in the last comment. They're already pending prior to these offenses. The new charge Ms. Hansen ended up picking up was because of some methamphetamine in her coat pocket. Ms. Hansen was reporting to probation. She was not using, she did not use. And the issue was, it was some old drugs that she had in her coat that was just there. Certainly it's her coat, it was her drugs. She admitted that it was hers, it's more than constructive possession. But again, she didn't go through those to clean out her belongings and her possessions. And perhaps that's the blame she should take on herself, and she does do that. But it is again important for the court to also know that it wasn't as though she was not following the terms of probation or using, because she did test clean and she was complying with the terms. It was just something that was left in her coat pocket, and she admitted to having it there, knowing that it was there, and there was possession of that controlled substance. So again, I don't know how much weight the court gives that, but I think certainly the court has the ability to understand why somebody who has drugs under possession, was not using it at the time, wasn't going through the terms of her probationary orders, but then picked up a new file.
Well, Mr. Haven, were you the supervising agent?
No, that's Mr. McFalda. I'm just filling in for him, but I mean, I have the reports. Other than that, I really don't have full background. Did you have a question regarding?
Well, I'm just
timelines?
curious whether she was, complying and testing negative.
I'd have to look at the computer record to confirm that.
Go ahead.
And I don't have that information. Ms. Hansen indicates that to me, that at the time she was compliant, she was testing negative. She was going through her Roscommon County case at the time, and there weren't plea negotiations. And this came up. And again, looking at the history of the file, she pled right away because she admitted that the drugs were there, it was in her coat pocket, and she knew it was there. She should have done a better job getting rid of things that she knew may or may not have been there. And that's what drug addicts do. They have their drugs in all different parts. So I wanted to just highlight that for the court that
I don't know if I can believe that somebody just misplaces methamphetamine. I think that's a pretty precious substance to the people that are using it
and I don't want to say that she misplaced it, she just never checked.
or forgot about it.
And that's what
I think
Ms.
people keep pretty close track of what they have and where it is generally. But that's neither here nor there.
But
I
again,
appreciate the argument.
but I think the takeaway is, at least I don't have anything at the time showing when she was arrested that she was using or came, to report to probation under the influence, came to court at the time under the influence, was in jail under the influence. I just don't have that. So I have to believe what Ms. Hansen tells me. I can't confront her that, hey, you found drugs in your pocket and, here you are using it. I don't have that missing piece. What I have is it was found in her pocket, she was arrested, and she was clean when she was taken in. So, and that's the reason why I asked that the court follow the recommendation. I don't think the top of the guidelines with that scenario makes sense. What makes sense is 6 months in jail. She is going to get sentenced in Roscommon. My understanding is with Roscommon, she's going to have a concurrent sentence that would be concurrent with this matter. And certainly the court, the recommendation is to revoke her 7411 status. Ms. Hansen understands those ramifications. She's now going to have 2 felony convictions, a low severity and a high severity felony on her record. And this was somebody that picked up these 2 felonies in a fairly short amount of time. So she knows that the seriousness of where she is, but she still indicates with all of these issues that have come up, she intends to maintain sobriety, continue with a path of sober living, continue with being sober and not use drugs. And I want to believe Ms. Hansen because of, again, some of the history of when she was on probation. I didn't have that, negative screens that were, or positive screens. I believe being told that there were screens that were negative and they were not impacting her use. So I think those are some steps that Ms. Hansen at least initially took. So I would ask you to follow up.
Ms. Hansen, anything?
I just take full responsibility, and I apologize to my family.
All right, so I read through all the reports. I'm familiar with what happened here. I was familiar with your case previously from the probation, and certainly not the way we were hoping that things would go. Things went on track after the last sentencing. I'm satisfied that there's an underlying issue here that you need to deal with when people have this many charges within a short period of time. It means they're really in the throes of addiction and they're not able to control what's going on regardless of what probation or bond or anything else is telling them to do. And I don't know about the stuff that was in your packet.
Mhm.
It's hard for me to believe that somebody is using them addicted to meth can just misplace any amount of it. Like I said, I think most of the time people are pretty closely guarded about that and where they have it and how much they have because they need to use it. And so weren't using it at the time, it's hard for me to accept that it's like finding a misplaced cigarette or something. I just don't think that's a credible story. But either way, I don't think it matters in terms of my consideration of this because I think there needs to be a couple of components with regard to the sentence here. Number one, there does need to be some consequence and some punishment because other people that are on probation need to understand that you need to comply. And if you're having issues, the thing to do is go to your aide and say, I need treatment. I don't know if I can stay clean. Help me get some help here. as opposed to just using it and violating. Or having it, possessing it, and then violating. So I think there needs to be a punishment component here, but I also think, these aren't violent offenses, they're not involving large amounts. This seems like personal use to me. This is something I think that you could benefit from some treatment and some help with. And I think, given your record, which is not that extensive, you've been on probation one other time, I get people that have been on probation 4, 5, 6 times. So I think it's worth more efforts at rehabilitation here, because I think this will help at least have an opportunity to get a hold of this. And, sooner or later, it's going to be up to you. I can order it all day long. But you don't have to do it because it's being ordered. You can do it because you want to do it. You want to break out of this cycle and you want to live a better life. And ultimately, that's what it's going to come down to, is what you want to do. And I hope that you do take the opportunity to do it. So I'm going to give you that chance through probation with some jail time up front, and the possibility of early release to go to an inpatient treatment and successfully complete it, not have to serve the rest of your sentence.
Yep.
And I think that addresses all of those components I talked about. So in terms of the probation violation, I think that's a good recommendation, the whole file. I think just discharging you unsuccessfully from that didn't go well. And I don't see a point in continuing that. So the court is going to discharge you unsuccessfully from your probation. That is file number 245333. The court is going to order that you serve 88 days of jail with credit for 88 days served. Again, discharged unsuccessfully with the 7411 revoked. All fines and costs that remain to be preserved in that file. With regard to the new file, the court is going to place you on probation for a period of 24 months. Again, the court's going to order as all the conditions of that probation, all the terms and conditions listed in this report. The court is going to order that you serve 6 months in the Crawford County Jail on that file with credit for 86 days served. The court will, after the first 3 months of that, the court would allow you to be released to an inpatient treatment program. You would receive day-for-day credit if you successfully complete that program, and the court would suspend any remaining jail time after you were successfully released from treatment. If you leave to go to treatment and you don't successfully complete it, then you won't receive any jail credit, and you'll be returned to jail to finish serving that sentence. The court in that file will order $130 state cost, crime victims assessment. I'm sorry, $130 crime victims assessment, $125 court cost, attorney fees of $350, $68 state cost, and supervision fee of $30 per month while you're on probation. You have the ability to appeal both of these sentences. Mr. Murphy, you have the appellate rights for.
I do, Judge. I did go over those with her. She has signed in the flowers receipt. Ms. Hansen has a copy of her report.
Ms. Hansen, those papers will explain to you how to appeal. Ms. Shady, anything further that we need to address for the record on this file? Either of these files.
Nothing further. Thank you, Your Honor.
Mr. Murphy,
No, sir, thank you.
Ms. Hansen, good luck to you going forward.
Thank you, sir.
Good luck, you. Take care, okay? Good luck.
Mr. Trush, are you ready on Mr. Butt's case?
Yes, Judge. We
Record in People versus William Butts, file number 204727 and 14739. The record should reflect Mr. Butts is present here in the courtroom today. These were added to the docket this afternoon. Counsel,
Dana Chady on behalf of the people.
Thank you, Your Honor. Richard Trish, appearing on behalf of Mr. Butts.
Mr. Trush,
Your Honor, we're going to be making admissions for the violations. He'll be admitting to 2 violations of state law. And I apologize, I'm trying to find my copies of the violations to get those.
I think I've got it. So, Mr. Haven, is that the agreement that Mr. Butts would plead to 2 of the violations of state law and have the rest?
Your Honor, this is Agent McFalda's file. He was not aware of this, I don't know if he was aware of this plea happening this quickly. But given what Mr. Trush had stated, the count on each file violating state law, it would be appropriate.
Okay. Butts, have you had a chance to talk to Mr. Church about this?
Yes, sir.
Okay. Is that how you want to do this? Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Butts, you understand that you would have the right to have a hearing as to whether or not you violated your probation in each of these files?
I do.
Okay. And you understand that by pleading guilty, you're giving up that right?
Yes, sir.
Also, by pleading guilty, could subject you to the maximum possible penalty. Number 214739. That would be up to 4 years. And file number 4727. That would be up to 10 years. You understand?
Yes, sir.
Follow that in mind. What is your plea to each of those violations?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything to get you to plead guilty?
No, sir.
Is it your own free choice to enter this plea?
No, sir.
Are you pleading guilty because you did violate probation?
Correct.
All right. On or about June 12th of 2024, were you on probation in both of these files here in
Yes,
Crawford?
sir.
Sorry.
Yes, sir.
Okay. And were you aware that one of the conditions of your probation in each file was that you were to not violate any laws of the state of Michigan? And did you violate the laws of the state of Michigan by pleading guilty to assault of individual with the last name of Hansen?
Yes.
And you entered that plea in Otsego County Circuit Court here today on March 7th.
Yes, sir.
Court is satisfied that the plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that Mr. Butts violated probation in each of these files. As alleged, the court would take note of the record. And testimony earlier under oath in Otsego County regarding the assault, which is court for the formal basis for violation of state law and violation of probation. Court will accept the guilty plea as to each file. We'll set this for a sentencing hearing. Mr. Haven, do you want to meet with Mr. Butts today just to set that up? Or is it already-
Yeah, I'll talk with him briefly and have him contact Agent McFalda. So
So Mr. Butts, just make sure that you follow up with that and your contacts with Mr. McFalda and Mr. Church, anything else that we need to address today?
No,
Mr. Haven or Mr.
Nothing further from the people. Thank you, Your Honor.
nothing further, Your Honor.
All right, thank you. That's all for today, Mr. Butts.
Thank you.
Report will be in recess until
So, Michael do a quick report. Just what-